Start. We have carefully gone through the impugned order. It would reveal that the learned counsel for the appellant as also the appellant were absent when the matter was taken up for hearing. The order would further reveal that after noting their absence, the court perused the records and ultimately passed the order impugned. However, the order does not reflect consideration of the case on merits. In other words, it is a non-reasoned order when an adverse order would affect the personal liberty of a person. The fact that he is a convict cannot be a reason to deprive him of fair treatment in the matter of consideration of his revision petition in the manner prescribed by this court. As the law laid down by this court in that regard is binding on all courts by virtue of Article 141 of the Constitution of India. In the decision in Madan Lal Kapoor versus Rajiv Thapar 2007, 7 SCC 6-3, a two-judge bench of this court held that the rule laid down by this court that a criminal appeal should not be dismissed for default would also apply to criminal revisions. The reference thus made was to the decision of a three-judge bench of this court in Bunny Singh versus State of UP 1996 4 SCC 720. In Bunny Singh's case, Supra, this court held thus. The plain language of section 385 makes it clear that if the appellate court does not consider the appeal fit for summary dismissal, it must call for the record, and section 386 mandates that after the record is received, the appellate court may dispose of the appeal after hearing the accused or his counsel. Therefore, the plain language of section 385-386 does not contemplate dismissal of the appeal for non-prosecution simpliciter. On the contrary, the code envisages disposal of the appeal on merits after perusal and scrutiny of the record. The law clearly expects the appellate court to dispose of the appeal on merits, not merely by perusing the reasoning of the trial court in the judgment, but by cross-checking the reasoning with the evidence on record with a view to satisfying itself that the reasoning and findings recorded by the trial court are consistent with the material on record. The law therefore does not envisage the dismissal of the appeal for default or non-prosecution, but only contemplates disposal on merits after perusal of the record. We are in perfect agreement with a view taken by the two-judge bench in Madan Lal Kapoor's case, Supra, and therefore even in the absence of a party or his counsel, a revision petition calls for consideration on merits in accordance with the parameters for consideration of a revision petition. In that view of the matter, without making any observation on the merits, we remand this matter to be considered anew. Taking note of the fact that the revision petition is of the year 2017, we request the Honorable High Court to consider the revision petition expeditiously. This appeal is directed against the order passed by the learned single judge of the High Court of Delhi in criminal revision petition number 42 of 2000 dated August 8, 2005. The learned single judge dismissed the criminal revision petition filed by the appellant herein by the order which reads thus. In spite of notice, nobody appears for the petitioner today. Criminal revision petition number 42 of 2000 is accordingly dismissed in default for non-prosecution. Over.